Okay, we're on the record in People versus Richard Gault.
Your Honor, Ryan Ziegler on behalf of the people.
And the yellow rabbit Merthy on behalf of Mr. Gault, who's used to the toilet left.
Mr. Gault, did you have a chance to go through the pre-sentence report with your attorney today?
Yes, sir.
Okay.
No, I want to withdraw my plea.
Okay. What's your basis for that?
14th Amendment of the United States Constitution provides no person shall be deprived of life, liberty, limb, or property without due process of law. Okay. Now, I'm sure, Your Honor, that you're familiar with the great liberality standard. The United States Supreme Court in People versus Benchek, generally, it is considered that there is no absolute right to withdrawal of a plea. But this court's decision suggests that the trial judge's discretion be exercised with great liberality when the motion is made prior to sentence or commencement of trial. I have a motion here with me today, Your Honor. The same great liberality standard is to be applied when the request is to withdraw a plea of guilty or no contender plea. The Benchek and Prodigy are founded on the proviso that the right to a jury trial is so important that exercising that right should not be impeded by belief in the defendant's guilt. Okay. Under Michigan Court Rule 6.310, withdrawal or vacation of plea, B, withdrawal after acceptance but before sentence. Number one, a plea may be withdrawn on defendant's motion or with the defendant's consent only in the interest of justice. In People versus Bonneville, a motion to withdraw a plea before sentencing should only be granted if the defendant is able to show that withdrawal of the plea is in the interest of justice, meaning the defendant has to articulate a fair and just reason for withdrawing the plea. Fair and just reasons are an actual claim of innocence or a valid defense of the charge. Your Honor, I'm innocent. My valid defense of the charge is I have DNA results from 2 different forensics labs of Jessica's fingernail clippings that say there was multiple contributors to DNA found under her fingernails, but there was no match to my DNA. Again, there was no match to my DNA under her fingernails. I have the Verizon Wireless report showing cell phone coordinates proving that the descendant and I were in different counties when the 911 call was placed. The Verizon Wireless report also proved that the prosecution can't even place the descendant and I in the same county as each other for the days in questions. That's right, Your Honor. The Verizon reports don't even put the descendant and I in the same county for the days the crime was taking place. I have the Verizon reports with me today. I have the DNA reports today with me for your review. I have medical reports with me today. Okay.
Mr. Gault, we had a trial. We had jurors. We were ready to go. Right?
I asked for a continuance to hire my own attorney, Your Honor, and you denied me a continuance.
Right. So we were ready to go to a trial. We had jurors here ready to hear your evidence that you have here with you today.
Your Honor.
You waived your right to that and you entered a plea on that day. So why should I now allow you to withdraw that plea?
I filed 4 motions for substitutes of attorney that were denied. Mr. Giramosi filed a motion and terminated his attorney-client relationship.
I know all of that.
2 months before trial.
That's not a reason for me to allow you to withdraw your plea. You knew all of that at the time you entered your plea.
A legitimate claim of innocence and a legitimate defense to the crime is reasons to allow me to withdraw my plea.
It's also reasons for you to go to the trial that we had ready and set with jurors here ready to go that morning.
With an attorney that terminated his relationship with me and we didn't prepare for trial, Your Honor.
You had plenty of opportunity. I'm not going to argue with you. You waived your right to that jury trial and your right to present all of that evidence that morning on the record. Right? I explained all your rights that morning, didn't I?
Can I finish reading?
Didn't I explain all your rights that morning?
Yes.
Yeah. And you said you understood them?
I've
right?
Never signed an advice of rights form in relation.
You stated on the record that you understood your rights, did you not?
Your Honor, I never signed an advice of rights.
That's not my question. That's not my question. My question is, you stated for the record that you understood all your rights, didn't you?
Your Honor, I have with me today medical reports that shows that Jessica died from internal bleeding due to cirrhosis of the liver. I have the medical reports right here with me for the family.
You had your opportunity to present all of that to a jury. And you declined that opportunity and you accepted a plea. Under the court rule that you cited, which is correct, NCR 6.310, you need to show that there was some type of error in the plea taking process. The plea taking process. That means what we did on the record that morning in taking your plea. So I need you to tell me what you think the error was in the plea taking process.
Well, Your Honor, I believe the error was the fact that you participated personally in plea negotiations with my attorney and the prosecutor in the judge's chambers.
Okay. How was
According
that?
to
How was
People versus Green, People versus Cobb, and People versus Killebrew, it says we hold that sentencing concerns are appropriate subjects for plea bargaining. However, we hold that judges' roles in plea negotiations, the sentence bargaining included, is limited to consideration of the bargain between the defendant and the prosecutor. The judge may not become involved in the negotiations. Due to the nature of unequal bargaining positions of the judge and the defendant, any involvement in the negotiations transforms discussions into perceived coercion.
Yeah, I was not involved in the plea discussions.
Mr. Karabosi told me that you,
I asked the attorneys whether there was a plea agreement, and they indicated to me that you wished to enter into a plea agreement, which you confirmed on the record.
Mr. Karabosi told me that you were willing to allow me to make a plea of no contest to second-degree murder, a plea offer that was taken off the table 2 months prior. I was told that the judge is not going to allow you a continuance to hire your own attorney, but he has agreed to allow you to plead no contest to the second-degree murder plea agreement that was taken off the table 2 months prior.
And that's what we put on the record that morning.
Right, that you were involved in the negotiation.
Not involved in the negotiations.
I am innocent, and I have a valid defense to the charge.
Okay.
I have
Right.
the DNA results.
All
I
right.
have the
Thank you.
bars and
You've
wireless
stated your
report.
basis. I appreciate that. Mr. Murphy, is there any other legal argument you'd like to make on Mr. Gault?
Regarding the withdrawal of plea, no, Judge. I've done my research. I've indicated Mr. Gault. Under the court rule, there was no legal error in taking of the plea. I've indicated Mr. Gault, the court was not involved in plea negotiations. Mr. Ziegler, the morning of trial, and the jurors were here, renewed a plea offer that Mr. Gault then accepted. That's the process of what occurred. And then we did ask the court if the court would allow Mr. Gault to enter a plea to release the jurors if he entered a plea. In my experience, once the jurors are here, this court is not allowed that to happen, and essentially, and all plea cutoffs essentially has treated that as a plea cutoff. And that certainly was not the case in this matter, because the court did allow, based on the renewal of the plea offer from Mr. Ziegler's office.
Correct. Okay. That's correct. Mr. Ziegler, any response to the people on the defendant's motion?
Just two things, Your Honor. As to what Mr. Murphy just said, I would confirm for the record that the plea offer has been the same pretty much since the inception of this case. The court was not involved in any negotiation or amendments to the plea offer. The offer in this case has been and has always been for over a year, at least closer to a year and a half, murder second. So there was no court involvement in the negotiation, just that the court allowed us to take the plea in spite of the fact that there was a plea cutoff prior. In terms of the actual innocence argument, Your Honor, I don't have any of these Verizon reports the defendant is claiming to want to present. I don't have these independent reports that Ms. Scott died of cirrhosis of the liver. Those are not the reports that were provided to me by Mr. Murphy. This is the first time hearing of them. I don't believe they either exist or that they say what Mr. Gault implies they say, but in any event, I agree with the court. If he wanted to present that evidence, we had a trial date ready to go. He understood that. He chose to plea. There's no palpable error in the plea-taking process. There's no interest of justice that would allow the withdrawal. And certainly I would further argue under 6.310B that the prosecution would be prejudiced by a withdrawal of that plea, as it took significant time and effort to prepare for that trial, which was going to span over 2 weeks and involved subpoenaing and coordinating over 30 or 35 witnesses on the prosecution side to appear to testify at that trial. Certainly allowing the defendant to withdraw the plea at this stage based on what the defendant has argued would create some prejudice to the people's side. So for those reasons, Your Honor, we'd ask the court deny the defendant's motion.
And Judge, I should make the record just clear that the only reports that I have, and I don't know what report Mr. Gault is indicating he has independent of what we have, is the defense's expert. If that's the report, then Mr. Ziegler has that report.
I have the
Well,
medical.
look, I'm not getting into evidentiary issues here today. This is way outside the scope of what the court would consider on a motion to withdraw a plea. So I appreciate your position, Mr. Gamerthy. I'm not going to go further down this road because I view it as a waste of time at this state, and I'm not going to allow Mr. Gault to continue to waste the court and everybody's time. And nothing has occurred between the interim, which convinces the court that he is actually innocent, or that it would be otherwise in the interest of justice to allow him to withdraw the plea. At this point, even if that were the case, for the reasons stated by Mr. Ziegler, there would be a high degree of prejudice to the people in allowing you to withdraw your plea at this late state when they were prepared, had all their witnesses ready to go for trial. I view your motion here today as a continuation of the strategy that you've employed throughout this case, which is to simply try to prolong things, to backtrack, and just another attempt on your part, just as demanding to go to trial, getting everybody prepared for trial, and then on the morning of trial deciding you want to enter a plea, now reversing your course on that. So for those reasons, your motion is denied. The court is going to proceed with sentencing. Mr. Gamerthy, are there any additions, deletions, or corrections to the report?
Can I just put one more thing
No,
on
you
record?
cannot. I'm sorry. I'm done.
I need to establish a record, John.
I'm sorry. I'm not going to allow you to do that. I've allowed you to state what you're going to state today. We're proceeding with the sentencing hearing. If you're going to continue to interrupt me during the process of this proceeding, I may have you removed and you can watch it on video. If you want to remain in the
Due to
courtroom,
my current
you remain
medication,
quiet.
I'm unable to make a spare of the moment logical decision first thing in the morning due to my medications. And I think it's in the interest of
I'm sorry.
justice
I'm
for the
sorry.
family to be able to see the
I'm
medical
sorry.
reports and the DNA results.
Sorry, we're not doing any of that today. We're proceeding with sentencing today. I'm going to give you one more opportunity to cooperate with the proceedings. If you don't, again, I'll make a decision about whether you need to be removed or not.
Quit looking at us, motherfucker.
All right. Let's take a break. Let's remove Mr. Gault from the court.
Okay, but go ahead.
Man, I have the medical records if you want to see them. I thought Mr.
Just going to take a short recess. We'll come back on the record in about 5 minutes. Those of you that are present by Zoom, I'm just going to put you back into the waiting room. And then once we continue with the hearing, I'll bring you back in. So, ladies and gentlemen, and I want to make the record clear, defendant's not in the courtroom at this time. Ladies and gentlemen, I understand this is a difficult situation for all of you. And I understand the need and the desire and the inclination to want to respond to things that Mr. Gault is saying here in the courtroom today. It's in your own best interest to ensure that Mr. Gault's sentence is upheld later, and interruptions and problems here in the courtroom are only going to complicate that. So you're not going to be helping your own positions in ensuring that Mr. Gault is sentenced and stays sentenced. Please try to refrain from making any comments to him, having reactions to things that he says or does, and directing any comments or any outbursts towards him during the course of this hearing. If there are any of you that feel that you can't do that, and again, I understand that, I'm going to ask you to leave the courtroom. You have an opportunity to view the proceedings later if you want to do that. Other than that, we're going to try and proceed again. If you can bring Mr. Gault out, please. I need to proceed with this sentencing hearing today without interruptions, unless you are directed or given the opportunity to speak. I'm going to ask that you don't interrupt me. I'm also going to ask that you don't address anyone else here in the courtroom during this proceeding. That's happened already. I'm not going to allow that. If you continue to do that, then I'm going to have you removed from the courtroom and we'll proceed in a different way. You understand that?
Yes, sir.
All right. Can you just state your full name for the court?
My name is Jennifer Ann Nolan's. I'm Jessica's sister. I guess I was lucky because Jessica would run to my house a lot and they got into their fights to relax. I think that dragging us out is just putting us through hell. You know what you did. They could get one organ to stop bleeding. I would ask that just be sentenced, and I don't want him to ever hurt another person's life. I just don't know how he can sit there and say that he didn't do anything.
Thank you. Any other victims, Mr. Ziegler, would like to address the court?
I don't believe so, Your Honor.
All right. Anything that you would like to say on behalf of the people for allocution?
Yes, Your Honor. Your Honor, this case has been pending for over a year and a half. I've poured countless hours into the investigation, the preliminary exam, the negotiations, the trial preparations. I've learned more about internal hemorrhaging and triage procedures than I ever cared to know before. And I will forever have the images from Jessica's autopsy burned into my brain. This has been one of the most violent, traumatic, and callous assault cases that I have dealt with in 8 years as a prosecuting attorney. By all accounts, this was a vicious beating delivered by someone who has a long history of violence. Jessica's own statements, preserved in text, and her final coherent words to emergency medical personnel described it as a 3-day ordeal. Nicholas Mitchell, a registered nurse there, said to Detective Bruzikowski that, quote, "This abuse was the worst he has seen," end quote, in 5 years as a registered nurse in the emergency room. The medical records show that when Dr. Strell performed surgery and opened up her body, he, quote, "immediately found 9 liters of blood in the abdominal cavity," end quote. For reference, the human body typically has 5 liters of blood in it in total. They pumped so much blood into her that night, again, quoting Dr. Strell's report, quote, "We had exhausted all our blood product resources," end quote. They pumped every drop of blood that they had available at Munson into her to try and keep her alive. Her injuries were so severe it was not enough. The second factor I want to address for the court is the defendant's reaction to hearing this news. The defendant didn't rush down to the hospital. He didn't call friends and family to get news. He doesn't go anywhere. He just goes into hiding. He tells multiple people he beat Jessica up, that he gave her a black eye, and he hit her in the ribs, etc. But he's adamant in his text messages that he did not kill her. When law enforcement detains his daughter, Sterling, she admits he's been hiding inside the residence with the door locked and that she's been taking supplies. She also admits the defendant told her he might have done it, that he hit Jessica in the ribs and it could have caused a puncture or internal bleeding. While the defendant is texting numerous friends telling them he didn't kill Jessica, a few of them mentioned to him that he has home security cameras and that those should help exonerate him, help him show that he didn't do any of this. However, when the police recover the home security system and have it analyzed, they found the system had been overwritten on October 27th and again on October 28th, and no videos before the 28th exist. The defendant proceeds to have an armed standoff with police, where he is in possession of firearms and body armor, and luckily his daughter is able to talk him into coming out of the house and surrendering. The defendant's hiding from police and probable tampering with evidence suggests that he is just as guilty as Jessica claimed he was prior to her death. It also strongly suggests a lack of remorse and a willingness to defy and evade law enforcement. The defendant's behavior and attitude throughout this case has been deplorable. Third, I'm going to talk about the defendant's criminal history. At a glance, Your Honor, a record of 2 prior felonies and 15 misdemeanors might not jump off the page for this court. I know we've dealt with worse records on other cases in the past, just in terms of quantity. However, on closer inspection, the defendant's record is atrocious. He's quite possibly the worst serial domestic abuser I have ever encountered. The defendant has 5 prior domestic violence convictions and 2 prior assault and batteries. On the surface, that's already bad enough, but digging into his history with his victims reveals that he has repeatedly and continuously abused his domestic partners for over 20 years. The defendant was in a long-term relationship with Kimberly Rootwright. Their relationship produced 2 children. Kimberly told law enforcement the defendant used to be a hard worker, but started abusing controlled substances and started drinking, and he would become violent when he did so. She recounted multiple instances of assaults between the 2 of them. She recounted one incident where she was choked so hard she vomited afterwards. She said the defendant used fear and manipulation to get his way. After Richard and Kimberly broke up, Richard married Krista Gault. Krista had a similar story for law enforcement. Initially, the defendant treated her well, but he abused drugs and alcohol and would become violent. She also indicated that she had been choked by the defendant. They divorced in 2012 or 2013. Defendant then began dating the victim's sister, Rebecca Buck. Buck told law enforcement the defendant would choke her, and he was, quote, really good with the kidney shots, end quote. After Rebecca broke up with the defendant, he started dating the victim, Rebecca's sister, Jessica Scott. Everyone who was asked by law enforcement to describe the relationship described it as some version of rocky at best. There's the fact that the morning Jessica went to the hospital, he messaged his friend Nate Kibbe and said he had to get out of the house before he, quote, killed this bitch. There's the gross manipulation of his daughter, which continued on throughout this case, having her send letters to witnesses, talk to people on his behalf, instructing her to dodge service, having her try to hire another lawyer literally the morning of trial. Just this week, yesterday, in fact, I learned that they have been having jail communications, having Sterling send medical reports, autopsy reports, DNA reports to the victims in this case, the family members of Jessica Scott, including the victims who are potentially going to be speaking at sentencing today, Your Honor, to try and influence, in my opinion, try and influence their statements to the court or to try and soften their views of the defendant. It's just more characteristic manipulation that he engages in. I truly feel sorry for Sterling Gault because she's been a pawn in his games for the last year and a half. And I hope she can one day see what her father has done, not just to the victim of this case, but to her and to her mother and to every woman that he's come into contact with. The defendant's actions have brought him here. His history of violence before the crime, the brutal and unconscionable crime itself, and the defendant's behavior afterwards all lead me to believe there is no alternative but to sentence him to the maximum term the court can give. I urge the court to fashion a sentence that ensures the defendant will never leave prison until the day he dies. Thank you.
Thank you. Mr. Gurmurthy, anything on behalf of Mr. Gault?
Does Mr. Gault, in lieu of preserving his rights, has asked me not to allocate on his behalf. So I don't have anything to add or allocate on his behalf.
Mr. Gault, is there anything that you wanted to say? The record should reflect Mr. Gault is shaking his head no. I obviously had an opportunity to review the suicide report. Had a lot of different motions in this case. The prosecutors talked a lot about the aggravating factors here, and I don't think I need to go through those again. I don't think certainly the victim's family doesn't need to hear about it again. Judge that I respect and admire and has been a mentor to me once told me that the more heinous a crime is, the less a judge has to say at sentencing because it's self-evident. I do think that a prison sentence at the top of the guidelines is absolutely appropriate. I think it's important that you're never allowed to have access to another individual again, that you have the opportunity to abuse in the way that you abused Ms. Scott and the other women that you've been involved with throughout your life. So for all those reasons, the court finds, again, a sentence at the top of the guidelines is appropriate. The court will sentence you to 450 months. That's 37 and a half years to 60 years in the Michigan Department of Corrections. You do have credit for 617 days served. There will be a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek sentence. Provide you with appellate rights. Let's see if you can provide that.